ladies and gentlemen. We have a quorum here, and we are past the time to get started. Representative Reeves, could I call on you to open us in prayer?
Let us pray. Dear Lord, we thank you for this time here in the House Judiciary Committee. We pray for wisdom, justice, and moderation in the 2025-26 term. And I ask for your blessings. In Christ's name we pray, amen.
Amen. Okay, I think the first thing we need to take up is the adoption of the House Judiciary Committee rules. Has everybody on the committee had an opportunity to read through these? And do they have any changes or any additions to it? Representative Oliver?
I don't remember, Mr. Chairman. Was our quorum 5 last year, or is that a new number?
It's the same as last year.
And we have 15 members on the committee?
I think it's closer to 18 or 17 or 18, yes.
Committees are different, but I've been trying to figure out if the majority of committees are 50% plus 1. I don't remember having a quorum of 5, and that's mine here.
Okay. It's my understanding that we've had a quorum of 5 for quite a while. And I've had meetings where that's about all I had here, because everybody on this committee is very popular on other committees, and so they end up going elsewhere. So.
But it's also a very engaged committee, engaging and engaged.
Yes.
Where people come.
Yes.
to important issues.
Right. And I'm careful about what goes forward on just 5 votes. So, okay. All right, got a motion. Do I have a second? Any further discussion? All those in favor say aye. Aye. Any opposed? All right, we have our rules. Okay, let's see, which one is it? All right, we're going to call House Bill 55, and Representative Ford is here to explain the bill.
Thank you, Mr. Chairman and committee members. Thank you for giving us this opportunity to introduce House Bill 55, which adds a 3rd judge to the Lappaha Judicial Circuit. I'd also like to thank my colleagues and my co-signers who have helped me with this bill, as this is my first bill. This circuit includes Atkinson, Berrien, Clinch, Cook, and Lanier counties. As you can see on the worksheet we provided, that the Lappaha Judicial Circuit ranked number 1 on the Judicial Council's workload study. I'd also like to point out that the caseload has doubled since the 2nd judge was added back in 1979. And though this circuit is mostly rural, I'd like to note that I-75, which goes from Detroit to Miami, also runs through the heart of Cook County, bringing 55,000 cars through that area daily. Also bringing with it an uptick in drug trafficking as well as human trafficking. So don't be misled. We are rural Georgia, but we have big city crime, to the point that Governor Brian Kemp and Attorney General Chris Carr came to Cook County to do a gang task force roundtable with the FBI and GBI in the drug task force a few years ago. Lastly, I'd like to point out that the funding for this additional judge is on the governor's budget. Now I'd like to introduce one of our 2 judges from the Lappaha Judicial Circuit, Judge Clay Tomlinson. I hope you'll welcome his comments and defer any questions to him. Thank you, Judge Tomlinson, for joining us.
You're a smart girl. All right, Judge, if you'll just pull it. Yeah, there you go.
Chairman Gunner, Leader F. Strayton, members of the committee, and my fellow Georgians, thank you. It's my honor and privilege to speak to y'all today. The Lappaha Circuit has the highest need in the state for an additional judgeship. I'm sure y'all are aware of the case count workload assessment, and it's been that way for some time. Not that we've been the highest, but we've been qualified for several years, both before and after the COVID crisis. The Lappaha Circuit does not have a COVID backlog. Y'all, we don't have a backlog. Myself and Judge Perryman, we're processing cases. We're working diligently to serve our citizens. What we do have over the past several years, I'm talking about a decade, is a sustained increase in caseload for our counties. This is criminal and civil cases, and the amount of time it takes a judge to handle cases has increased through the years. As Representative Ford said, we received our second judge way back in 1979, and a lot has changed since then. Over 45 years, our 5 counties have seen a 33% increase in population, and case counts have doubled. There's several factors for that, y'all. National crime rates have increased. Our nation's divorce rate has gone up 60% since 1979. And our courts have to handle those divorces and multiple custody and child support hearings and visitation hearings that last through that child's minority. Landlord-tenant wrongdoings have increased, and our courts deal with those as well. Tort lawsuits have increased. And the state of Georgia has been meeting the increase in court workload with their own agencies. The state of Georgia has created a child support enforcement division since 1979. My state probation office back then had 2 probation officers. We have over 20 surveillance officers today. The state has given the DA's office in 1979 2 attorneys. Today they have 9. Y'all have created a public defender's organization for this state. And it started off in my circuit with 2 attorneys. They now have 6 positions. This whole time, our circuit's been functioning with 2 judges. We've really reached our maximum on the workload and the service that we can do our citizens. Y'all, I live in a poverty area. We're rural Georgia. Our poverty rate is 26%. A third of the cases that come before me on my civil calendar are self-representative, people without an attorney. And these types of cases, as Representative Scoggins knows, they're a little challenging. You have to slow down. You have to explain things to these people. And a lot of times we actually have to continue that case for them to correct clerical errors on their paperwork. I don't want to dismiss the case. I want to hear the case and give my citizens a resolution based on the merits of what's going on. That takes time. Now, we're trying to self-help. We have law libraries, and they are helping fund a local legal aid organization that meet with these non-represented individuals and review documents and give them some advice before it comes to court, and that helps. It is multiple days that myself and Judge Perryman go to more than one courthouse. We travel 5 counties. My citizens can't chase me around the circuit. They don't have the funds or the ability to do that. When they have an emergency in their life, I have to go to where they're at. As I said, we have 2 trial court judges, and Representative Ford has done a good job in informing you that our rural location is we still have serious and complex cases before our courts. Locally, our city and county governments unanimously support this idea of our 3rd judge. We have the amenities, physical space, and the ability to support a 3rd judge immediately. We know where we're going to put this person. We're ready for them. To paraphrase Chief Justice Glenn Terrell of Florida, no judicial system can hope to rise above the character and quality of its judicial officers. Judges are the very lifeblood, the source from which wisdom, justice, and moderation arise. And a judge must meet the needs of those persons seeking justice. A court-provided justice is a must for a peaceful, moral society. In the Arapahoe Circuit, we need an additional judge to provide for the needs of our community. On behalf of the citizens of the Arapahoe Circuit, I thank you for your support of House Bill 55 and the access to justice it will promote in my area. Thank you for your time.
Judge, thank you. I have a question that you said that the counties in the circuit are agreeable to having another judge added on. Is that right?
That's correct.
Y'all have an agreement, a judicial circuit agreement for the 5 counties?
We have letters of support from all 5 county county commission offices signed by the chairman, as well as all 5 sheriffs, multiple police chiefs, and city council members. We've got 5 counties, and all 5 of those have space for a judge and the supporting staff to go into immediately.
Okay, great.
Yes, sir.
All right, thank you. Questions by the committee? Who's on number 6? Representative Holcomb.
Thank you, Mr. Chairman. I see the percentages. Can you give us the raw numbers in terms of the size of the population, not a percentage increase, but the actual numbers? And also, what is the current caseload per judge?
Yes, sir. currently, my population for all 5 counties is about 65,000. In 1979, it was 66% of that. I don't know the exact number off the top of my head on the 79 figure. And our current workload assessment number is 1.42. And some members of the Superior Court Council are here. They come up with the workload assessment number. If it's okay, I would defer to them to explain how that number is derived and what it means.
I'm happy to hear that, but in terms of like your actual caseload number, what is that? If you can give us context and maybe both civil and criminal of what's on your docket. Do you have an understanding of that?
Oh, well, in 5 counties, I have about 8,000 cases open right now.
8,000.
Yes, sir. And that's two judges. Yes, sir.
Does
That's
the judge
everything.
does the other judge have a similar
No,
caseload?
total? That's both of us.
Okay.
Yes, sir. And that's everything from a speeding ticket to a multiple murder case. That's everything from a dispossessory action being appealed up from a magistrate or probate court to complex tort litigation where there's been an explosion in a building and multiple people hurt.
Okay. That's a lot. Thanks.
Yes, sir.
All right, who's 18 over there? Chairman Smith?
Mr. Chairman, just at the appropriate time.
Okay, all right. I got one more to go to. All right, Vice Chair?
I know supplements may be moot shortly, but I know the committee's asked a lot over time about supplements. Have the counties committed to supplements or discussed that?
I've been a Superior Court judge for 8 years. I've been the Chief Superior Court judge for roughly 5 years. When I was elected, no county in my circuit provided a supplement.
Okay.
My counties now do provide a modest supplement that I'm very grateful for.
And follow-up question, the other judge is former DA.
Yes, sir.
Right.
Yes, sir. Judge Perryman. Yeah, wonderful man.
Thanks.
Yep.
Okay.
He's on the bench today working.
Somebody's got to be there, right? Yeah. Okay. All right. Any other questions from the committee? All right. Chairman Smith?
Move to pass.
Have a motion and a second. Any further discussion? Hearing none. All those in... I'm sorry? Yes, sir.
It's my understanding that generally we start these January 1st instead of July 1. That's how we usually appropriate them? Or are we going to make that change in this version?
I understand that they had a reason for leaving it this way, so I'll refer to y'all. Which, do you know?
Given our dire need, we like it sooner rather than later, but we'll take it any way we can get it, Chairman.
Okay.
I just generally thought that was going to kind of be the preference from the Appropriations Committee, but I, defer to that here.
Have Representative Ford, have you talked to anybody in appropriations about how this is going to be funded? Okay.
It was in the judicial budget that came over, and it is a line item budget in Governor Kemp's budget for the Alapaha Circuit to have the additional judge.
All right. Leader, illustration.
Mr. Chairman, isn't it, or to the sponsor, isn't it true that we've carried bills like this in the past? I've carried one in the past that we often will work with the appropriators as the budget process goes forward. If we need to make corrections later, we can always do that. But as far as the effective date, that shouldn't be something to hold it up at this stage.
Yeah, and I would agree with that.
Yes, sir.
All right. Thank you. Any further discussion? All right, I got a motion and a second. All those in favor say aye. Aye. Any opposed? All right. You got your bill coming out. Now, we have a form for you to fill out, or that we'll fill out, and that way you can take it up. So, is rules operational yet? Not yet.
Thank you very much. Thank you.
Yeah. First bill of the session. Okay. Let me sign. There you go. All right. Chairman Leverett, you have House Bill 36, and you can do it either way you want to, because we're going to fill that hot seat with some folks that support it and oppose it.
Given my substantial girth and difficulty negotiating this corner right here, if I can, I'll just do it from here.
Okay, which mic are you on?
16.
16. There you go, sir.
Thank you, sir. Thank you, Mr. Chairman and members of the committee, and I appreciate your attention today. Mr. Chairman, I did bring my frequent flyer card. If you could stamp that when I leave later today, since I think this is, I don't know how many times I've presented bills to this committee, but I appreciate the chance to. I appreciate you putting the bill on the agenda. So House Bill 36 may look familiar to you. As one of my favorite philosophers once said, it's like deja vu all over again, because you've seen this substantially the same thing before. So this bill expands the list of professionals who can provide an evaluation of a proposed incompetent adult in a probate court proceeding to appoint a guardian or a conservator for that adult. Currently, physicians licensed to practice medicine, psychologists, and licensed clinical social workers can provide evaluations. Or if the proposed ward is a patient in a federal medical facility and there isn't someone licensed under state law, one of those disciplines who is licensed to practice and authorized to practice in that federal facility can do the evaluation. So I know some of you practice in this space, some of you don't. This is basically where you have an individual who can no longer tend to their own business or affairs, or doesn't have sufficient capacity to make decisions about their own health care. If it's for health care purposes, it's called a guardianship. It's for money and property, so they can help manage that, it's a conservatorship. The bill would add to the list of people who can provide an evaluation. And again, if you're familiar, you generally have to petition a probate court to have someone declared. You're in essence, you're not technically declaring them incompetent, but to get a conservator or guardian appointed is what we colloquially would think of as the same thing. You're having somebody appointed as an officer of the court who has authority to act for someone who is deemed unable to have the mental capacity to act for themselves or make decisions for themselves. And you generally do that by filing a petition with the probate court. You serve it on interested parties, and you're supposed to have an evaluation with it, or you sometimes get the evaluation after filing before it can proceed. And so who can do the evaluation? Who can evaluate someone and say whether a guardianship or conservatorship is appropriate? And that's generally the list of people we've talked about. We're adding to that list physician's assistants, nurse practitioners, or clinical nurse specialists in psychiatric and mental health who are licensed under the Georgia law, and then marriage and family therapists or professional counselors. In Section 13, the bill also clarifies the definition of gross settlement for purposes of determining when a conservator can settle a claim by the ward or against the ward. And that was the original bill I had several years ago that we added Chairman Scoggins' bill to. He initially filed this bill during the last biennium. It went over. It got off the floor of the House, passed. I think it was in juvenile justice, I believe. Passed that committee, passed the House overwhelmingly, got into the Senate, passed out of the committee, the Children and Families Committee to which it was assigned, and then got stalled for reasons which we will not give detail on today. But it got stalled in the Senate, so it was added to a bill that I had, which was about the gross settlement. And it passed House Judy unanimously, or close to unanimously, and didn't make it to the floor. Then last year we got it back out of Judy again, and we just couldn't get it on the floor. And I think at one point we added it to another bill in the House, so it passed the House again. And we have had no opposition to the bill at all, and it's substantially the same as it was. I understand today there is some opposition, and you will hear from them, and I certainly respect their position, but also respectfully disagree with it, at least as I understand it now. I have not really heard that much from them until earlier today, so I will let them state their position. I think they can state it much more eloquently than I can. But I think the main reason, why are we doing this? Well, the reason is the need for a guardian or a conservator is such an emotionally wrenching decision and an emotionally wrenching time. You're basically suing somebody, sometimes a parent, sometimes a close relative, sometimes a close friend, to have a court find, yes, you can't make decisions on your own anymore. You need someone else to make them for you. It is such just a draining, exhausting, emotional ride. And currently, these cases tend to languish because they cannot find physicians and other current professionals that are on the list to provide the evaluations. And so the cases just sit. And all the while, there's frequently a somewhat urgent need. There is an emergency process allowed by law, but even when you don't need the emergency procedure, there's still a fairly dire need for the appointment. And so we're trying to allow those to move forward with people that we feel are still qualified to make that determination, who can do it from an independent third party, so that you know that someone's not trying to take advantage of someone. I think that's sort of the concern. And it's just terrible to have these cases languish. So we're trying and just stall. So we're trying to provide a process that'll relieve some of that pressure. We haven't had opposition. We believe that the people we are adding to these lists are very, very qualified to make these determinations. We've not had opposition from physicians and other people already on the list to provide the evaluations, and we would ask your favorable consideration and your due pass recommendation.
Okay. All right, I have a question. Who's got 12? Representative Oliver.
Thank you, Mr. Chairman. I had forgotten this language about $25,000 beginning on 412, and as I look at line 412, and as I look at it right now, just trying to remind myself, the gross settlement is not $25,000. It's X amount, including medical expenses, which are always frequently very high, and any amount of allocated structured settlement. Does that mean it's all these monies have to be under an allocated structured settlement, or is it a separate two different things? Do you see what I'm saying?
Yeah, my understanding is the way that I think the genesis of this section is we made some changes several years ago to minor settlements, and we're trying to make the language consistent. Not necessarily make it identical, but to use similar language so that there aren't sort of matters of interpretation raised by the language we did some years ago in the minor context, and to try to clarify that. But to your question, my understanding is everything that would be paid is included in the term gross settlement.
And not only included in something defined as a structured settlement. That's why I'm confused. It looks like the gross settlement and the structured settlement are the same thing. Tell me if I'm wrong about that.
Well, it says any amounts allocated to a structured settlement or other similar financial arrangement. So I'm assuming if it's allocated, if a portion of the settlement is allocated to some kind of structured settlement, you include it in your total. And if you get, I believe as I understand the way the statute works, is if you're 25 or less on your gross settlement, the conservator has the ability to settle those claims without going through a lengthy court proceeding.
My structured settlement definition, that's my problem right now. I don't know where structured settlement is defined, but in the code anywhere. But to me, it means something buying an annuity over time, all that kind of stuff. So that's what I'm trying to figure out. If the average is $25,000 is sufficient.
Well, I think if you have some payment being made that's to buy that annuity, that would certainly be included in the total that you would have to add up to figure if you're at 25,000 or not. And again, the issue is, do I need to get court approval for this settlement, or can I simply do it on my own?
I'm going to vote for it, but am I the only one that sees that confusion there?
Well, I know the lady has a rather unusually high degree of expertise and knowledge of this area, because this is sort of your wheelhouse. So I guess I would say apparently that I believe that's similar language to the other statute, and I'm not aware that it has caused any sort of concern amongst the probate judge community of interpretation. But that's certainly something I'd be willing to look at
Thank you.
if needed. And I appreciate your comments on that.
Okay. Representative Holcomb, you waive? Okay, all right. Any further questions? All right, we'll start out with Elizabeth Apley. And I don't know which mic you want to use.
Okay, it's a better one.
Well, just let me know. There
How
you
about
go.
this?
That works.
Thank you, Mr. Chairman. My name is Elizabeth Apley, members of the committee. I represent the Georgia Association for Marriage and Family Therapy. We support the legislation. Thank the author and Representative Scoggins for moving this forward amid a serious expressed need from the probate courts. Licensed marriage and family therapists are included in the mental health professionals that will be added to the list of eligible persons to provide evaluations for guardianships and conservatorships. Keep in mind that those evaluations are required not only to create a guardianship, but to change it or to end it. So there is a pathway out. Social workers have been included among the licensed professionals able to perform the evaluations for a number of years. And as you may know, those social workers, along with marriage and family therapists and licensed professional counselors, are all regulated by the same professional licensing boards. They have comparable education, training, and experience and skill sets. MFTs have been licensed in Georgia for over 25 years. We're licensed in every state in the country. These are masters and PhD educated professionals. They're part of the core mental health professional team. They are entrusted with legal responsibility to evaluate, diagnose, and treat mental health and emotional disorders. They have at least 2 years of postgraduate clinical experience before becoming licensed and also pass a national licensing exam. They have the same privileging granted in 4310A as the LCSWs and LPCs, and the same authority to initiate emergency mental health evaluations through 1013s. They're included as mental health providers under Medicare, Medicaid, and most public and private health insurance. This evaluation is but one step in a long process for guardianships and conservatorships, combined with legal representation, which is mandated, multiple steps of judicial review, and court hearings. The standard for appointment of a guardian or a conservator by the court is only, quote, if the court finds the adult lacks sufficient capacity to make or communicate significant responsible decisions concerning his or her health or safety, and the guardianship must be found to be in the best interest of the individual. Finally, this is all 29.4.1a and c, and then in F, all guardianships ordered pursuant to this chapter shall be designed to encourage the development of maximum self-reliance and independence in the adult, and shall be ordered only to the extent necessitated by the adult's actual and adaptive limitations after a determination that less restrictive alternatives to the guardianship are not available or appropriate. If you look at pages 4 and 5 of the bill, you'll see the elements of the evaluation. These are unchanged, but they're illustrative about what the evaluator is to look to in determining the proposed ward's mental and physical state and condition, their social condition, the existence of support, care, education, well-being, and their needs. So you've got a self-report from the ward, who has the right to have an attorney present. They question and observe the ward to assess their functional abilities. They consult other people knowledgeable about the proposed ward's condition, review medical records, medication, and other available records, and assess cultural factors and language barriers that may impact their abilities and living environment. Tests are also available to be utilized. I'll add, I care very much about this issue. I've been involved in advocating for people with disabilities my entire professional life, which is long, The very first case I ever tried as a baby lawyer was representing a young woman with a developmental disability whose father was trying to have a guardian appointed, and I won. So thank you for your consideration. I'm happy to answer any questions.
Okay, any questions from the committee? Seeing none, thank you. All right, I may jump around a little bit on the list here. Sheila Jeffries? Okay, just tell us your name and then tell us what you want us to know.
Good afternoon, committee. My name is Sheila Jeffrey. It's not.
Jeffrey, okay.
Yeah, it's Jeffrey. I opposed against the guardianship. I just have a brief testimony. Again, my name is Sheila Jeffrey. I live in Atlanta, Georgia. I lived most of my life in institutions like Brook Run, Central State. I'm not sure that a lot of people probably, though, thought I should have a guardianship. Why I've been living in the community. People also thought I should have a guardian when things weren't going well for me. I have been able to find a group of people who I trust and who trust me to support me when I need it. Through conversation, supported decision making. My doctors listen to me, my banks listen to me, my support coordinator listens to me. I listen to my circle of support. I now live where I want to live. I live a life is where I want to be. I would not have this life if I had a guardian. Supported decision making should always be the first consideration before guardianship. I have my rights and my choices should be respected and supported when I need support. I do not believe this bill is necessary, and I believe it would hamper the rights of many people with intellectual and development disabilities. And to add on, I have a traumatic brain injury, which also causes me to have seizures and other physical and mental disabilities. And I feel like with guardianship, if this bill is passed, people with, not only myself, but people, if they were to have guardianship, they would be afraid to, and I fear that if there's choices that when guardianship is put on people with disabilities, they're going to be afraid to go to the doctor and not having that choice of what doctor they go to or mental health and people to talk to, because I was told when I left the institution that I would need guardianship. I told them, no, I can get me a support team, which I have a support team. I do not have a guardian. And I feel this bill does not need to be passed. I think people with disabilities should have their own choices and rights of where they should live, where they want to eat, where they want to live, and who they want to be, and everything. So please consider this bill. Thank you.
Okay. Hang on just a second.
Okay.
Any questions for the witness? Chairman Leverett.
Thank you, ma'am, for your testimony. I just wanted to try to drill down a little bit and figure out, why do you feel the particular changes that this bill proposes to make, none of which relate to the standard of imposing a guardianship, would create a danger of guardianships being improvidently granted for people with disabilities?
Because I know people right now that has guardianship, and they're right now can't even make a choice to where they want to eat, where they want to live. And I know, like I said, I know people right now that has guardianship can't even make a choice of what doctor they want to do, where they want to live, and they're held hostage right now. So guardianship is not a place for people with disabilities. That's just how I feel.
Okay. All right. I don't see any other questions. Thank you, ma'am.
You're welcome.
LJ Jeffrey or Jeffries?
Young.
Je-
LJ Young.
Young. Okay. Yes, sir. Yes, sir. You can. That is 18.
Whoa, do you really got it? That's why I said don't touch it with 10-foot pole.
Hello, my name is OJ Young. I live in Atlanta. My journey is I used to live with my grandmother, and then and she had a stroke, so I had to move here to Georgia with my mom. After that, I was put in a group home after a little while, and because my mom is my mom, when I wanted to go into community living service, which is living in your own apartment, living on your own, or living with a roommate that you trust, my mom told me that if she had guardianship over me, she would have told me no. And I would have been devastated because I don't like living in a group home. Most people I know don't like living in group homes. They want to live on their own. But the guardians say they have to because they're scared of taking risks. And I believe that this bill will make it easier for families, friends, professionals, and especially the parents of people with intellectual and developmental disabilities to manipulate and control the person that they're trying to get guardianship over just because they're afraid of letting them make their own decisions. I am scared that it will be abused. You can make up lies to get guardianship. I'm pretty sure there are stories of people who have lied to get guardianship because they just want to have control over that person. This will make it easier because you're making it to where other people, other than licensed professionals, can make the evaluation for guardianship. And that really scares me. Because what if the person comes with the person who wants to have guardianship over them? They can manipulate the person giving the evaluation instead of it being by a licensed professional. So that is why I am totally against this bill for everything.
Okay.
Thank you.
All right. Thank you. Any questions by the committee? Thank you, sir. All right, I'm going to call Robin Pinston. Is that right?
Got it right.
Oh, good. Good guess.
I'm Robin Pinston. I'm a family nurse practitioner, Director of Government Relations for UAPRN, which is United Advanced Practice Registered Nurses of Georgia. I also have my own geriatric house call practice in Cumming with several NPs, and our practice is serving the elderly in their home and in institutionalized settings. So nurse practitioners, we do over 1 billion visits a year throughout the country. For our standardized curriculum in our education for graduate, master's prepared nurse practitioners, we're fully capable of completing cognitive assessments, utilizing standardized testing and screening tools for cognition, for functional assessments, for behavioral issues, memory, attention, language, reasoning. They're all part of our standard of practice. Primary care NPs and house call NPs serving the geriatric community, we're sometimes the first person or provider that a lot of our folks see. So we're the first ones who are going to diagnose and see any issues with cognition, negligence, not taking medications properly, and behavioral issues. So with that said, we're very capable of signing guardianship.
Okay. All right. Any questions? Chairman, Vice Chair.
Ms. Pengen, all right, so you're a licensed professional,
Yes, sir.
right? And physician's assistants are licensed professionals,
Yes,
right?
sir.
Nurse practitioners are licensed professionals, right? Licensed professional counselors, of course, are licensed. Certified nurse specialists and licensed marriage and family therapists, all licensed professionals.
Correct.
You have professional duties, you have extensive training to get that. Thank you.
Correct. We do.
All right. Seeing no more questions, thank you.
Thank you.
All right, Julianne McConnell.
Thank you. I represent licensed professional counselors and UAPRNs in the state of Georgia. So we have, just like Robin Pington, who testified today, and we'll have our LPCs, our licensed professional counselors, that will be testifying. I also represent the Service Providers Association for Developmental Disabilities, and that's the association. We have over 8,000 individuals that are served by providers that are members of our association. This legislation, as he said, this has been 3 times that it has been presented, and our SPAT has not opposed the legislation. We did not realize at that time that we needed to get involved, and so I did not have enough time with the board to get for them to meet yesterday to have a decision by the board. But they did tell me that as the bill before, that they do not oppose this bill.
Okay. All right, hang on just.
Okay.
Vice Chair Reeves.
Ms. McConnell, the current law is doctors and psychologists, and that's a fairly narrow and small group of people to do these evaluations. Would the licensed professional list that we went through with Ms. Pengen, including some of your licensed professionals, would that expand the number of people available to look into these situations in court proceedings?
Absolutely, and I actually, because I had worked with Representative Scoggins and Representative Leverett on this bill for the past, as they said, we actually passed it 3 times in the House, overwhelmingly, and just really ran out of time this last session. There was no opposition even in committee when we took it to the Senate. And it's basically because of physicians, psychologists, and licensed clinical social workers. And number one, that's a limited number for a probate court judge to be able to reach out to and utilize. And then also, many times, especially when you're trying to get a physician to come and provide that service, sometimes that can be challenging too. So they just wanted to expand that list of qualified, available healthcare professionals. And that's what this bill would do. Just like licensed counselors, we have over 10,000 licensed counselors in the state, and they serve throughout the entire state of Georgia. So they would have access to, and that's just one of that list to make it available. So when they do need to have a guardianship appointed, they can reach out to a qualified, available healthcare provider.
Okay.
And with probate court being the court for these evaluations, a county of 1 million people has the same number of probate judges oftentimes as a county much smaller than that.
Oh, absolutely. And I actually, when we were trying to get the bill passed, we do what we can sometimes to help encourage the passage of that bill. I even reached out to the probate court judge in my hometown in Carroll County, and even to our lieutenant governor's probate court judge, who expressed that they certainly needed this bill, and that they strongly supported it, and was asking for support for the bill.
All right. Any other questions? All right. I don't see any more. Thank you.
Thank you.
All right. I got 2 left. I want to call Charlotte Dinsmore at this point.
In the spirit of not speaking for people with disabilities, is it all right if I'm joined by one of our council members?
Sure. Yeah. Come on up.
Yes, ma'am.
All right. I got both mics live. So.
Thank you.
Mm. Okay, who goes first?
I'm gonna let Jessica
All
speak,
right.
and I'm here to support and answer any questions you might have.
Tell us your name and then go ahead and tell us what you want us to know.
Good afternoon, committee and chair. Thank you so much for having us to speak. I'm Jessica Cowell. I'm coming from Columbus, Georgia today. I am part of the Georgia Council on Developmental Disabilities, and we have a statement that we have prepared, and I'm going to read it for you today. Thank you for the opportunity to speak. I really appreciate it. Guardianship is a profound legal intervention that strips individuals of fundamental rights, including the ability to make decisions about their finances, medical care, and personal lives. For people with intellectual and developmental disabilities, this decision can have lifelong implications, including the loss of autonomy, independence, and dignity. Because of this, the determination of guardianship must be approached with utmost care, guided by rigorous professional expertise and capacity assessments and decision-making abilities. The proposed expansion raises concerns because many of the listed professionals, while highly qualified in their respective fields, do not have specialized training in evaluating an individual's cognitive or functional capacity. This evaluation requires nuanced expertise to ensure that guardianship is only imposed when absolutely necessary, and that less restrictive alternatives are considered first. The risk of overusing or misapplying guardianship disproportionately impacts people within the IDD community, potentially leaving them vulnerable to unnecessary loss of rights and autonomy. Moreover, the most effective and widely recommended alternative to guardianship is supported decision-making. Supported decision-making allows individuals with disabilities to retain their rights while accessing the assistance they need to make decisions. This approach promotes independence and self-determination, aligning with the values of inclusion and empowerment that Georgia has long championed. By expanding the list of professionals without ensuring adequate training or emphasizing less restrictive, like supportive decision-making, this proposal risks eroding the right of individuals with IDD. Despite claims that expanding professions who can grant guardianship will also find a way out, evidence shows that an individual granted guardianship is rarely able to get out of one. I urge the committee to reject this expansion and instead focus on initiatives that protect rights and promote independence. Thank you for your time and consideration.
All right, thank you. Any questions by the committee? And ma'am, do you have anything you want to say?
I just wanted to emphasize in response to former questions, the concern is really with the licensing experience. Of course, those professions are licensed in their respective fields, but we understand that intellectual and developmental disabilities are a very unique set of circumstances that require licensed professionals in that field. And the concern is that folks included on this list, such as marriage therapists, do not have expertise in the field enough to take away an individual's rights. I mean, guardianship is a very heavy topic. You are stripping someone of their human rights when they go under guardianship. So I urge the committee to consider that as you expand who is able to strip someone of their human rights.
All right, I have one question. Chairman Leverett.
So I suppose my question is, what specifically about this expansion causes you well, you said it's because you don't believe that the professions we're adding to this list have particularized training
Yes, sir.
with respect to the abilities of people with disabilities.
Yes, sir.
Right.
That's correct.
I'm just curious, what training do right now a physician can do it? So
Sure.
a podiatrist can provide an evaluation.
Sure. Yes, sir.
And so what particularized training would they have with respect to the same topic?
Sure. That's a really great question. My understanding is they have medical training that I don't believe marriage therapists undergo
Well,
in terms of better understanding of disability.
okay, all right, well, fair enough. I guess I don't see how medical training would necessarily help you in the evaluation of someone's competence to make decisions for themselves. I don't see that would make a significant difference. You've got the training on mental health, which is ultimately what this sort of relates to. You generally don't have a guardianship or conservatorship, to my knowledge, just based on a physical disability. It would be an inability to make we recited the standard.
Sure. Yes, sir. Yes, sir. That's a really great point. I'm not sure exactly what training they undergo, but my understanding would be that it's more rigorous than what a marriage therapist, for example, would undergo. Do you want to speak to that, Jessica?
Yes. Yes. When you spoke about it at the beginning, you talked about how when you're in this situation, it is highly emotional and difficult for people. Often when people are in marriage counseling, they're at a space that's also highly emotional and difficult. I worry personally that someone who is a marriage counselor may not see the full aspect of the person they are treating within those sessions. Sometimes during those kinds of sessions, some people may not be fully honest about what they're experiencing, and the counselor isn't living with them, so they may not have a full scope of what's really going on. Historically, people have sometimes used ways of controlling people. Back to that place. And this makes me very nervous for that kind of situation.
Well, and I understand. I don't doubt the sincerity of your concern. I don't think, for example, the concern you've expressed seems to me it would apply equally to a medical doctor as well as to a counselor.
Yes,
You're
sir.
talking about an ability to assess veracity
Sure.
when in an evaluation. And that's, to me, the doctor arguably is less. I think the marriage counselor might have more expertise and knowledge of particular patterns that they could seize better there. I think the testimony has been they do have sufficient training to assess competency and mental capacity of people, more so than say I would as a lawyer. So I respect that concern a lot, and I agree. I hear a lot of concern that sometimes guardianships and conservatorships are improvidently granted with respect to people with disabilities, and that is a very legitimate concern. I don't really feel like I don't quite understand why this bill in particular impacts that,
Sure.
other than I think you're concerned that they're just not qualified to make the evaluation.
I don't think they're unqualified. I do think that when you're with a medical doctor, you're not in a high emotional setting the way you may be in a marriage counseling setting. I'm sorry.
No, don't apologize. Don't apologize. And just to speak to it on the whole, our concern is with guardianship, period, and this is an expansion of that. Our
And
preferred
conservatorship also.
Yes, sir. Our
Okay.
preferred alternative is supported decision making, which we've seen to be a better alternative for people with intellectual and developmental disabilities. and this is an expansion of guardianship and conservatorship that's very concerning to us.
Well, and again, I understand that
Yes, sir.
concern. I just don't feel like this particular expansion impacts the sort of general opposition you have to the improvident granting of guardianships in situations where they're really not appropriate. And I guess I think that's the disagreement we have on that, and I think that's the decision the committee is going to have to make.
Absolutely. We appreciate your time. Thank you.
Yes,
very
ma'am.
much.
Thank y'all too.
All right, got one more. You gonna wait? All right, any other questions from the committee? All right, seeing none, thank you.
Thank you very much.
Thank you.
All right, next we have the Honorable Kristen Poland from Cobb County Probate Court. And I'm gonna ask, are you the judge?
I am one of the associate judges.
One of the associate judges.
I don't have to sit in the hot seat for election every 4 years.
Okay.
So.
All right.
Right. Thank you very much. Okay. All right. Thank you so much, Chairman and members of the committee, for allowing me here to speak. I am here on behalf of the Probate Judges Council. We are in favor of this bill. I want to talk a little bit about guardianship in general, and our job as the probate judges and how this will help us, and then answer any questions that the committee might have. I want to echo what Ms. Jeffrey, Mr. Young, and Ms. Cowell said. Guardianship is serious business. This evaluation is a piece of evidence that gets us there. This evaluation doesn't remove those rights. That's what I do. Those rights are only removed by a judge who considers the totality of the evidence presented. The petitioner then has a clear and convincing burden of proof in a hearing. Every single guardianship has a hearing. But what we're here about today is the other part of every single guardianship and conservatorship, and that is the statute requires that we judges appoint an independent evaluator. On a regular guardianship and conservatorship, not an emergency, the timeline on that often reaches 3-4 months, that these are pending cases. We have, it's very heightened emotional time for these families, for these individuals. And that's because the list of people who can do these evaluations is just very narrow right now. And their house calls on top of that. So I don't know how many of y'all can get a doctor on a house call, but if you can, I'd like the name of that person. And these need to be done on an emergency basis within 72 hours of the filing of that petition. And so if you can get a doctor on a house call, then try to add a 72-hour requirement to that. That's what the code requires us to do in order to complete our jobs. And that's a part of the very important due process rights of these people, which we, I want to make clear, take very seriously those due process rights. And we want to make sure that these are done correctly and that they're not being abused. So that being said, just it was, I apologize, I don't know what the year was that the licensed clinical social worker was added to the list of professionals that can perform these evaluations. That has been a huge benefit to the probate judges. We have, I'm in Cobb County, we have almost 800,000 people in our county. We have 4 people on our list who we can call on to do evaluations. 3 of the 4 of them are licensed clinical social workers. And we share those people with other counties. Those aren't just our dedicated folks. These people are very busy, and so we often have to schedule these evaluations out months in advance, which just drags the process out. And then, as I said, with the emergency procedure, all of that timeline is compressed into 72 hours. And that is a lot of work for a court to find someone to be able to do that evaluation in the next 72 hours from the time somebody walks in our office. The other issue is that, in Cobb County, we're actually very fortunate to have 4 people on our list. There are plenty of counties in rural Georgia who don't have doctors or psychiatrists or psychologists in their county. Those people just don't exist. And the independent evaluation is, like I mentioned, it's a piece of evidence that the court uses to consider, but it's important because it is not, the independent evaluation isn't, that doctor isn't chosen by the petitioner. It's not chosen by one side or the other in these guardianship proceedings. So having a list of people that truly is a third-party neutral evaluator, I think, is just an essential part of the process, and making sure that we as judges have all of the information and can make the best decision that we can make in those difficult situations for these families. And so, you know, the other part of that is that a lot of these smaller counties and things like that end up having to rely on telehealth and things like that as far as the evaluations. That creates its own set of difficulties with broadband access, with people's ability to access the technology to do those types of evaluations. So this is just kind of expanding our tool to be able to do our statutory duty under the code. And with that, I don't think I have anything else that I had prepared, but I am ready and willing to answer any questions that you all might have about the procedure in general or about this bill.
Okay, I have some questions for you.
Okay.
Who's got number 4 over there? Representative Evans.
Thank you, Mr. Chairman. Thank you, Judge.
Thank you.
2 questions, if I might. First, I was wondering if you could ballpark for us the percentage of times that when these requests are made that they are granted, at least in your court.
As far as guardianships
Yes.
in general?
Yes.
I would say the majority are, I don't know that I can give you numbers. I would say the majority are granted, but it is not a rubber stamp. I have denied plenty of guardianships, even where the evaluation said this person, you know, meets the standard for needing the guardianship and conservatorship, because as was mentioned earlier, that's just a piece of the puzzle. They may meet the standard, but if there are less restrictive alternatives available, if that person executed a power of attorney or a healthcare directive or something like that in the past, that the guardianship and conservatorship isn't required or doesn't really move the needle or doesn't benefit them, then I've denied plenty of them. Sorry, I don't have raw numbers.
No,
for you.
I didn't figure you would have the exact. I would have been very impressed if you had told me 72.4, but I appreciate knowing that generally. And then my second question is, now I know you said you don't know, and I don't either. Someone here may know when the licensed clinical social worker was added in addition to the actual physician. But for the petitions that you see, could you ballpark for us how many have an actual doctor do the evaluation versus a licensed clinical social worker?
Okay. Well, let me clarify. So
Okay.
of the 4 people on our list, 3 are licensed clinical social workers. 1 is a PhD. He's a psychologist. Okay. He's retired, and that is the only reason he is available to do anything for us. He probably, honestly, it's at least 75% of them are done by LCSWs in our court.
As opposed to an
As
MD or a
opposed to
PhD?
we have no MDs on
No
our
MDs.
list, not a one. We have 1 PhD on our list, and he probably does 25% or less of the evaluations in our court.
And I lied. I actually have a third question, if that's okay, Mr. Chairman.
Go
Sorry.
ahead.
What efforts are made by the court, or perhaps through a governing body of the courts, to your knowledge, to try to recruit people to these lists?
Oh.
Is it that doctors are asked and they say no, or no one's asked?
Yes.
Okay.
Yes, that is true. We've done everything from put out the call on social media to going and speaking to organizations and kind of the governing organizations and associations. Hey, come be an evaluator for us. But that call is rarely answered. But we do periodically just kind of put that call out in a number of different ways. I know Judge Wolk, she's the chief judge in Cobb County, has probably worn out a few pairs of shoes running from association to association, asking that they help us recruit members of their association to do these. And we just struggle to do that. Like I said, they're house calls. So we're asking somebody who might have a practice or whatever to drop what they're doing and go to an individual's house, to a hospital, to a nursing facility to an assisted living facility or any wherever this person who's the subject of the petition for guardianship might be, perform an evaluation, fill out our form, because we don't like anybody else's forms. We want to use our own, which they're not familiar with, and then do all of that and get it back to us in 7 days, which is what's required under the code as well. So nobody seems to be, doctors and psychologists don't seem to be chomping at the bit to do that.
Understood. Thank you.
All right, I'm gonna jump to this side of the room. Floor Leader Hong.
Thank you, Mr. Chair. Judge, thank you. You clarified a lot of my questions, but I'm still a little confused of just the process.
Sure.
So a petitioner files with a statement from one of these licensed licensed people that we have on there currently, and then does a court look at that petition and determine that there is probable cause, and then also have a separate evaluator that you will appoint, and that will be completely different from the initial, what was in the petition?
Yes.
Does that make sense?
Yeah, it does make sense. So there's two ways that a petition can come through the door. Either two petitioners, meaning two people who just know a person. You know, it may be two children of an adult with dementia, for example. Or one petitioner who has a supporting affidavit from one of these licensed professionals. If the court determines when that petition is filed that there's probable cause to believe, I mean, it's just a probable cause standard at that point. If the court believes there's probable cause to proceed, then we order a separate evaluation by a separate individual to occur. That then, when that evaluation is performed and that the evaluator's report is filed with the court, we make a second probable cause determination in order to set the matter for a hearing. So it can be dismissed at any of those points along the way if probable cause isn't met. Then when we get to the hearing, we have the petitioner's burden by clear and convincing evidence to meet.
And does the list of licensed professionals that you have, do you have their resume and or their specialties? You know exactly what their training is, et cetera?
In our court, we essentially have them apply for the job and give us their resume, show us what, we check and make sure that the licensing is valid and is in place. It's not, and that they meet the requirements, the code requirements, as far as, there are some definitions in there that they're licensed under chapter such and such. So we make sure that the licensing is in place. We have them send us their resume and before we add them to our evaluators list to call upon. Now, that applies to our evaluations that we order at that second step. At the initial step, where the petitioner could file with a supporting affidavit, that's any doctor or any psychologist or any LCSW out there in the world can sign off on those, and we don't, as long as they have sworn that they have that license, then that gets it at least through the door of the court. So
thank you.
That makes sense. Yes, ma'am.
All right. You can tell lawyers love having judges on the witness stand. All right. Representative Kelly.
Thank you, Mr. Chairman. Judge, good to have you here with us. Help me make sure I have a clear understanding. I hope I do. I've represented proposed wards and defended them successfully against a guardianship conservatorship. I've been appointed as guardian ad litem over proposed wards and have at different times defending those successful. And then I've petitioned the court on behalf of family members or others for guardianship conservatorship. Once that petition is filed and you decide to move forward to probable cause, what legal representation will the proposed ward have?
So on an emergency guardianship, we immediately appoint counsel, and we have a list of attorneys who handle those types of cases. So they immediately are appointed counsel. In a non-emergency guardianship and conservatorship, they are served personally with the petition, meaning the sheriff or a process server hands it to that person. They have 48 hours. If within 48 hours an entry of appearance hasn't been entered on behalf of that proposed ward, then we, on day 3, appoint them a court-appointed attorney. That attorney is not a guardian ad litem. That attorney represents the individual, the proposed ward. So they are not there to tell me what's in that person's best interest. They're there to advocate for their client, who is the proposed ward. We can also appoint guardians ad litem. There are certain times when we must, and that relates a little bit to the other part of this bill with settlements and things like that. If settlements are over a certain amount, if properties to be sold, those types of things, we're required to appoint a guardian ad litem. But the code also allows us, in any case where we just think that we would like that report of a guardian ad litem, we can, as a court, appoint a guardian ad litem as well, to kind of give us the picture from that person's point of view.
And so as the attorney appointed for the proposed ward,
Yes, sir.
I would have the same ethical and legal obligations that I would for any client to zealously advocate for my client.
Absolutely.
Including if I saw the report, not to pick on anybody, say it's a well-established doctor, psychiatrist, and I say, man, I've dealt with that doctor before. The guy's crazy. He don't know what he's talking about. I'm going to go hire my own expert. There would be provisions in the law for me to be able to go out and hire my own expert to defend against the petitioner's expert in the case here too, correct?
There absolutely is. You can file a response to that evaluation as a proposed ward. You can get your own separate evaluation from someone chosen by you as the proposed ward. The entire Civil Practice Act applies to this, so we can have 6 months of discovery in a jury trial if that's what's demanded. So all of those provisions do apply here, yes.
And then, of course, you as a judge in a matter like this, much like any other matter under the Civil Practice Act, you weigh the weight and credibility of the witnesses, the experts here in this provision to see, along with any other witness testimony or evidence at hand, correct?
Yeah, absolutely, and those people are subject to cross-examination. You can depose that doctor. All of those things are available to the counsel of the proposed ward.
Okay, thank you.
Thank you.
All right, Chairman Leverett. Thank you, Mr. Chairman. Thank you for your time, Judge, here
Thank you
today,
for
your
having me.
testimony. So the sense I'm getting is in your county, you have tried to engage members of the medical profession, medical doctors, about being evaluators, and the response has not been exactly overwhelmingly
Not robust.
affirmative. Yes. Is it your understanding that that's a similar experience judges have in other counties?
It absolutely is. We share our evaluators with several other counties who all kind of call on the same group of evaluators that are willing to do these types of things and have made themselves available.
The willing ones who appear to me largely not to be medical doctors.
Largely, we're talking LCSWs, yes.
Okay. And so does, well, I think you've already testified actually that with the current people that you are able to get as evaluators who are statutorily eligible and qualified, you are having trouble keeping the cases moving at what would be in your mind, a more responsive rate to the needs of the people who file these petitions.
Yes, that's 100% true, yes.
Okay.
Yeah.
And so, and is it not, there already, to my understanding from looking at the code, is there already are statutory requirements that in considering all the evidence, including the evaluation, that anything you do, if you order a conservatorship or guardianship, you try to encourage development of maximum self-reliance and et cetera. There's as I read, there's a statutory provision on that in both the conservatorship chapter and the guardianship chapter, correct?
Yeah, there is, and there's also provisions to allow the participation and decision-making of the proposed ward to the extent that that's appropriate.
Okay. So to the extent we're hearing concerns about the appropriateness of guardianships and conservatorships in certain situations with people who have disabilities, I'm hearing that that's something they would be able to argue in the proceeding and that you would consider as part of your determination as to whether conservatorship or guardianship was necessary in the first place.
Mm-hmm.
And if it was necessary, you would still consider it in crafting the particular provisions of that conservatorship or guardianship.
Absolutely. So we can, that we call that a limited guardianship or a limited conservatorship. There are a list of rights removed under a plenary guardianship or conservatorship. There's maybe, I think, 5 or 6. I'm sorry, I don't have those right in front of me, but they don't all have to be removed. And when we do our final order, the Supreme Court has a standard form of those final orders. We have to initial which ones we're removing, if it's all of them, if it's some of them. So those can be crafted to be more limited. Yes, certainly.
Thank you so much for your time.
Thank you.
Thank you, Mr. Chairman.
All right, Vice Chair Reeves.
Judge Poland, you're here on behalf of the Probate Judges Council, right?
That's correct,
And
sir.
who were some of the judges who were involved in leading the organization these days?
Oh, well, we have Judge Christopher Baller is the current president. He's Gwinnett County's probate court judge. I believe our Scott Chastain from Gilmer County is our president-elect. So that rotates every year. The president of the council serves a one-year term. As we've mentioned before, this bill has kind of shown its head for the last, I think, 3 years. So it's been through 3 presidents now of the Probate Judges Council. And it's been something that's kind of been discussed long before that amongst our members as well. So
Thanks a lot.
thank you.
All right. Looks like that's about all. I thought we had some wisdom coming from the non-lawyer. No, Pat. Okay. Okay. All right. Great.
Thank you so much.
Thank you. All right. That's it. Thank you very much.
Thank you so much, everybody.
All right. Anybody else that didn't get signed up that wants to speak? All right. Hearing none. Oh, got another. Judge?
It's proper time.
Okay. Any discussion about the bill at this time? All right, let's go ahead and do it.
Motion
Wait a
to
minute. I got one. Hang on.
Okay.
Who's number 4?
Sorry, Mr. Chairman. Is it okay if I ask a couple questions to the author?
Sure.
And I apologize to the author and I apologize to the advocates on both sides of this issue, because a lot of times things come through these committees, and I certainly voted on this bill before without asking the questions that I'm going to ask today, and I fully own that. And that's why for the individuals who came, it's so important that you're here, because you cause us to ask questions when perhaps we wouldn't otherwise have done so. So I acknowledge that I haven't asked you this until then, and for that I apologize. My question is, and Judge Walk from Cobb County is a personal friend, and the idea that I am questioning this bill, she's smacked me, but I understand the concern, and I understand the plight, and I understand the struggle that the courts are having, and I want to be very cognizant of that, and I'm aware that there's oversight here, but I do want to know a little bit more about what went into making the list of the people that we were adding, and how that compares to what that list looks like perhaps in other states. And I was wondering if you could enlighten me on those 2 questions.
No, sorry.
Good question. I'm afraid I don't know. I don't know if any of the witnesses did. My understanding is what went into, in terms of the types of disciplines or professions we're adding, and I assume that the witnesses present will correct me if I'm wrong, but I think the sense was they have sufficient, or they have sufficient training, first of all, to evaluate, but they also have comparable training to some of the people that already can evaluate now. And so and I profess, I don't know personally. I've never been through clinical social worker training myself. I've never been through, nurse practitioner training. But I understand from people who I think would know that the training is comparable and they're qualified to make these kind of determinations. I think if we had a sufficient supply of medical doctors and psychologists and clinical social workers to do the evaluations now so that the cases could at least move. And keep in mind, they may not move toward a guardianship or conservatorship being granted, to the judge's point. Sometimes they're dismissed at different points along the way. My recollection from doing a few of these is there are a couple of different points at which the judge, at least pursuant to the probate court standard form, has to make a determination expressly on the record as to whether the case can keep moving. So my understanding is there's comfort that we are not subjecting people to being evaluated by folks who are not qualified to do it.
Do you know how it compares to other states?
That I don't know at all. I don't know if we can get that or have a sense of that.
A doctor, a psychologist, a physician's assistant, a nurse practitioner, a clinical nurse specialist, a clinical psychologist, those indicate to me some degree of medical training, which gives me a lot of comfort. And no offense to professional counselors or marriage and family therapists, but I would like to be enlightened a little bit on what kind of clinical medical training those individuals have, because those are very different names. And if anybody can alleviate the concern that I am trying to articulate, would be very helpful. And maybe that's you, maybe it's somebody else. And again, I apologize for not asking sooner.
Well, no, that's fine. We weren't aware of the opposition until less than 24 hours ago. So that's I share your same apology.
Judge Scoggins.
Thank you. To add a little to Representative Evans' question, we did check other states, and they use very similar examiners to go out and do these guardianships. And the reason that we had such a problem getting these done, medical doctors and psychologists don't want to leave their office. They don't want to have to come to court and testify. They were getting paid, and this may be different now, but $125 for an evaluation. Is that pretty much?
We just changed it as of January 1st. They get $200 now.
$200. So medical doctors and psychologists don't want to be removed from their office to come to court to testify, and that happens lots of times. And but these examiners are very similar to other states in Tennessee, Alabama. They do the same thing, and they have the same problem we do.
So in other states, you think professional counselors and marriage and family therapists would be on the list?
I do.
That it?
That's it.
All right. Any further discussion about this bill before we move on? Ready to hear from you. Got a motion? Got a second? Any further discussion? All those in favor of this bill say,
One more.
Hang on. Came in the last minute there.
Sorry. I again acknowledge I voted for this bill before. I have real concerns, not because I don't trust our judges, but there's a lot of things that in this state we have laws that we require people with certain training to do, and we make those laws for a reason. And just because people don't want to leave their offices or just because there's a shortage, I don't know that we should cut our standard. That's what I'm concerned that we're doing here. And not because I don't have great respect for professional counselors or marriage and family therapists, but I don't see the clinical experience that I have comfort in feeling that a proper expert opinion is being presented in court. And there's a gatekeeper function there that those of us who do trial work are familiar with the Daubert standard, and I just don't think you can, under that standard, if we were in a regular trial situation, I don't think a professional counselor or a marriage and family therapist would pass the Daubert threshold for something that we normally ask a medical doctor or someone with clinical training to do. And for those reasons, with all due respect to the author and those that are in favor of this bill that I respect greatly, I'm going to be voting no.
I believe we did get, you have something you want to say? Chairman Leverett?
Just one inquiry. Does the lady feel that licensed clinical social workers have greater clinical expertise than the professions we're adding?
Well, the truth is I just don't have comfort one way or the other, but that clinical title conveys something to me that I don't see in the other professionals that are listed, and that's my concern. Maybe as this moves through the process and goes to the Senate, and that comfort can be provided to me, and this comes on the floor, I'll have a different vote. But as far as today in the committee and the responsibility I feel as a legislator, because of how serious a conservatorship is, I'm just not comfortable voting yes.
Sure. Respect the lady very much. Respect the concern. I think having done them, I think there's numerous opportunities along the way for that particular issue to be weighed in the particular case and for a just result to be reached. But I certainly respect the concern. Thank you, Mr. Chairman.
Okay. Vice Chair Reeves.
Mr. Chair, I would, as I'm deliberating on this, I know plenty of primary care doctors who currently meet the statute, who I think are arguably less qualified to evaluate, the mental health circumstance that leads to guardianships than these 3 or 4 different licensed professionals that are being added to the statute. I think that the focus on, is this person someone who is in need of a guardian based on mental health or other circumstances. I think these professionals that Chairman Leverett is adding to the list, that will help evaluate the core question better than a primary care doctor or some of the people who are currently on the list. I think these are the people who see these situations the most. They encounter these situations where people are in need of a guardian, and they're the ones who see it the most, and I think are probably most familiar with the problem. Doctors can still do it, but I think adding these professionals who see these on the ground every day will help have qualified people evaluating these serious things for the sake of mental health and care for people in need of a guardian in Georgia. So I'm supportive.
Okay. Representative Kelly.
I was sitting here looking up some of the requirements to be licensed on these in Georgia. I didn't make it real far. I got to marriage and family therapist, and I am hesitant to say I'd be trying to change your mind because I've admitted that before, and I'm usually doesn't work. So I'll say I'm offering something for consideration, and at least when I looked at marriage and family therapist, I do know part of being licensed in the state of Georgia in that occupation does require 2,000 hours of clinical training prior to being able to get that license issued. Just, again, something for consideration.
Any further discussion? Seeing none, we have a motion and a second. All those in favor say aye. Any opposed? No. Ayes have it. And that'll be it. That's the last of our work here today. Thank you, ladies and gentlemen. Have a good evening.